Any mention?
May please, Your Lordship, I beg to mention item 5, Your Lordship.
No objection, Lordship.
I prefer 2 weeks' time, Your Lordship.
Pre-made by petitioner, this is matter of 2 weeks.
Much obliged, Your Lordship.
May please, Your Lordship. Lordship, I beg to mention item number 9. Lordship, I pray that this matter may become up after 1 week.
Look at you, 2 weeks.
Much obliged.
But I beg to make a mention of item 3, my lord. But if it is taken up after 2 weeks.
In fact, in this case, I have completed my argument, Your Lordship. In this
Only thing
case,
is that, my lord, the arguing counsel is Mr. Guru, so he is not available today, my lord.
will be next week, Lordship. This is a long pending matter, Your Lordship, of 2022.
1 week.
1 week, my lord. And I also
Pre-made by Mr. K.P. Bhattacharya, Laratji, seeking accommodation on the ground that the Learned Conducting Council, Mr. Groom Lanerji, is having some personal difficulty. That is adjourned. This is after 1 week.
Hurry up,
but, I also beg to make a mention of item 11, my lord. It is kindly taken up after this.
Who's for the?
No objection, Your Lordship.
This is also Mr. Guru.
Yes, my lord.
Lordship, one more thing. I bring the type copy of the FIR, Your Lordship.
It doesn't matter. Let the matter be called up. It's in 1 week, is
My lord.
1 week.
Obliged, my lord.
May I please, Your Lordship? Your Lordship, I beg to mention item number 8 on behalf of Ma'am Seema Bhattacharya, counsel for the petitioner, essays on account of her medical treatment. Kindly allow us 2 weeks.
Who's for the?
Item number 8 here.
You are for the
Here
petition.
on behalf of respondent number 8.
I'm from the counsel for the petitioner.
Pre-made by on behalf of Miss Leonard, counsel for the petitioner who is indisposed. That is adjourned. This is after 2 weeks.
Please, Your Lordship, I beg to make a mention of item number 12. Lordship, it is connected matter with item number 10, 16 and 17.
You are in all these cases. You are there.
Your Lordship, I am only in 12, 16 and 17, Your Lordship.
Oh, that. Okay.
Also, hot spring matter, Your Lordship, in item number, this is a part head matter. In item number 12 and item number 17, already finished our.
So 10, 12, 16 and 17.
17, Your Lordship.
Yes, who's appearing for the state?
Then 16.
So I'll reply.
You are here, Mr. Sheikh?
I am not here, Lordship. Not here. It's a part-heart matter.
In 10, you are not the appellant. Oh, you are the appellant in 10. So 12,
16 and 17.
16 and 17, you are the appellant.
Yes, Your Lordship.
Legal aid.
Yes, Your Lordship. Item number 12 is not legal aid.
12 is not legal aid, but 16, 17?
16 and 17 is legal aid matter.
On payment by the appellant. This is matter up to 2 weeks.
Much obliged, Your Lordship.
10, 12, 16, 17. No?
The release item number 1.
Please, Your Lordships. In this case, my lord, the CD was called for on the last occasion, my lord. And in fact, my lord, today is 176 days behind bars. Not only the charge sheet has not been filed, supplementary charge sheet has not been filed as yet, my lord.
Supplementary charge sheet.
Yeah, but they were
The
supposed
charge sheet has been filed.
main charge sheet has been filed. 3 were arrested initially, my lord. They were,
Instead of default bill doesn't come.
in fact, the other 3, my lord, they were granted default bail initially, my lord. So for the other accused are concerned, my lord. Only thing, my lord, in this case, I'm a victim, my lord, victim of circumstances. What had happened, my lord, I had sent certain consignment, nimbu pani, mango juice and something, my lord, drinking water, my lord, through a vehicle. And that vehicle, my lord, unfortunately was carrying some contrabands, my lord, fancy deal and Tentadol tablets. And in fact, the vehicle was apprehended. And in fact, what has happened is, I had made calls to the owner of the vehicle and the consignee, my lord. And only on the basis of these 2 phone calls, my lord, I am a victim of this case, my lord. I was arrested on, my lord, 8/12, and since then, my lord, sorry, 12/8, my lord, 12/8/2025, and since then I'm in inside bars, my lord. If your lordship says I'm not named in the FIR, if your lordship will see the FIR at page 13.
Not necessary that you,
That is
that your
understood.
name, because
Only thing
eventually in course of investigation, it may transpire that you are involved.
Even in the earlier charge sheet, my lord, I have annexed the copy of the charge sheet here. The only allegation is that, my lord, that I had made 2 phone calls to the owner of the vehicle and the, my lord, and the consignee, my lord. In fact, the consignee, my lord, the wife of the consignee, my lord, and in fact, the consignee, he has also been, my lord, arrested because, my lord, probably, my lord, the driver and the handyman said that, my lord, the goods. Well, there is a difference between contraband and the consignment and goods, my lord. But they said the goods belong to the present, my lord, accused. But the fact remains, they have never stated that the contrabands belong to me, my lord. Goods were, I have admitted in my petition, even in the bail order, which was rejected by the London Sessions Court, my lord, special court, there is mention. I have admitted the goods are mine, my lord. In fact, I have the invoices of the goods, I have annexed with the bail petition. It's not I'm not denying the fact that goods were mine, my lord, but the fact remains, goods were mine, my lord, the contrabands were kept underneath, my lord. There was a chamber in the Bolero vehicle, my lord, and those things were kept there. But I am a victim of circumstances, my lord. For the last 176 days, my lord, I am behind bars. And in fact, I am having, my lord, kidney problems. There is fatty liver, and in fact, my wife is also required to be operated for, my lord, eye operation, my lord. That is immediate, my lord. So, we are considering the entire facts, my lord, and there is only another 4 days to go. Otherwise, we are for default bail, my lord. May I pray, my lord, that at least, my lord, my case may kindly be considered for bail, my lord. The CD was probably here, my lord. Lordship will go through the CD.
Yes. You brought the CD?
An extract copy of my lord, the entire CD has not been forwarded to us. I just have an extract copy of the FF.
Nothing is here.
Exactly, my lord.
Whereas statement of witnesses, Panchnama. Have you got a copy of the charge sheet?
Yes, my lord. It is at page 17, my lord, of the bail petition, my lord. The original charge sheet, my lord. Page 17, annexure E. And my forwarding is at page 37, annexure F, my lord. If your lordship kindly comes to page 35 of the charge sheet.
Yes.
The last part, my lord. Further, I also pray upon your honorable court to kindly allow me to submit supplementary charge sheet against Sri Om Prakash Tanwar and Sri Bijoy Saha as and when they are arrested. The witness noted in so and so shall. Now, Om Prakash is the owner of the vehicle, my lord. He is the owner of the vehicle, my lord, and the consignee and the, my lord, driver and the handyman, they were arrested and released on default bail, my lord.
And the accused here,
I am Bijoy Saab.
how are you related to the accused?
My lord, my goods were sent by the vehicle, my lord. I had sent, if your lordship, those things are also matters of record, my lord. I'll just, if your lordship kindly comes to page.
Who is Bijoy Saha?
He is the present accused, my lord, in the present bail petition, my lord. If your lordship kindly comes to page 15, annexure C and annexure D, my lord.
Page 15?
Page 15, 1-5, annexure C. Well, this were the goods which were sent, and annexure page 16, my lord. This is a lordship will see the 1st of March 2023.
Yes.
So these goods were sent in that particular ill-fated vehicle, my lord, which Lord, we are not aware, my lord. And in fact, nothing was seized from the conscious position of the petitioner, my lord. In fact, petitioner's brother, the brother of is the petitioner in this case. I'll face trial, my lord. The other 3 accused are already on bail.
My lord, there's a reason as to why the bail was rejected at the trial court, my lord, at page 41, lordship, of the application. At paragraph 11, lordship.
Yes.
My lord has it. In this case, the IO submits that there are CDRs called detailed records between this accused and the persons from whom the commercial quantity contraband was recovered. The petitioner admits that the accused had hired the vehicle, albeit to deliver nimbu pani and fresh mango juice. There appears to be prima facie material to show that the accused was in contact with the other accused from whom the contraband was seized. As at present, there are no reasonable grounds to believe that the accused is not guilty of the offence. Then, my lord, the applicant, the accused has come forward before this honourable court, my lord, seeking bail on grounds of health, lordship. My lord, we, as per the directions of this honourable court, on the last occasion when the motion, at motion stage, we had informed the concerned police officials as well as jail that the, due care should be given to this accused person, my lord. So, due care is being given, my lord, for these 2 reasons. When the bail was rejected at the first instance, there is a prima facie connection between the accused person and the other accused person. They were in contact, my lord. And this is commercial quantity, lordship.
Where is the details of this CDR?
CDR, my lord. My lord, I have to apologize, my lord, because my assistant counsel is still on leave, lordship. So I'm really sorry. I've just come from court number 1. My lord, just give me 2 days time, my lord. I'll contact the district.
You see, what would be relevant here is the content of the conversation,
my lord,
between the parties. Call can be made to anybody. I can make a call to anybody, you can make a call to anybody. It's the substance of the call that matters. If that, links the accused to the offence, perhaps.
In fact,
apart from other evidence. But since this is the main, the main cause as far as this arrest is concerned, can you produce these details? 2 days.
2 days time, my lord.
The lordship may fix it because it will be 180 days. So below that,
Charge sheet has already been filed.
No, lordship. I'll just leave it to your lordship.
Question of default bill.
Charge sheet is already filed. Kindly let it come on Friday, my lord.
Yeah, Mr.
RDA.
Friday then?
Lordship.
Or you tell me, whatever is convenient to you?
Lordship.
You're coming from outside?
I'm coming from Guwahati, my lord. Not in Shillong.
Can you come on Friday?
Yes.
When the matter was called up, Ms. Sheila Larat, additional senior GA, has submitted that the case diary as called for by this court could not be produced in its complete form. it is prayed that some more time may be allowed for the same to be produced, particularly as far as the accused person herein is concerned, the details of the CDR which is said to be the basis of his implication and arrest in this case. Mr. Learned Counsel for the petitioner has no objection to the preamble. Accordingly, as prayed for, this is matter for the hearing on 6th.
Much obliged, Lordship.
I'm deeply obliged.
Item number 2.
She's the appellant here.
No, in 2 you are there.
No, I'm the appellant, but you'll be doing yours. I finished my part, Lordship.
If I understand correctly, this matter is linked to another appeal, isn't it?
Yes.
13.
This cross appeal item number 13.
It's there in the list today.
Yes.
It's in the list.
So we'll take it up, at the same time.
Yes, she's the judge is supposed to argue item 13. We have finished our argument here. So the reply from the government and Mrs. Bhattacharya's argument. So I will give my response.
So what do we do? We finish this off and go to item 13, or we start with item 13 and continue with this?
So the issue is on the maintainability. Would be best if 13 is started first.
Maintainability.
13 is on maintainability. So
let them satisfy this court whether the appeal is maintainable.
It's for admission hearing.
No.
It's for hearing.
It's for hearing. Maintainability of the means my cross appeal is also
The core issue is that.
Core issue is that I raised cross appeal.
The serious matter goes into the merits of the case, but this is on the
maintainability of the appeal. Means I raised cross appeal.
So let her address on
You may have raised the issue. Cross appeal may have been filed.
Yes.
I believe the court must have passed an order.
Yes, it is admitted.
Allowing the appeal admitted.
Yes.
So now what remains? Why?
No, cross appeal.
That's a slightly longer issue.
Cross appeal, my lord, to make it more simple, cross appeal, I challenged that the entire proceedings award was not challenged, and award was not on record, and award was not challenged. So indirectly, my cross appeal will be as a maintainability challenge of their appeal, of the Madam's, our senior counsel, Madam Hazarika's appeal. My cross appeal will be. So let cross appeal be heard together. Only let item number 13
can be taken up.
Taken up together. So now, according to your lordship conveniency, let other matters be called up, and item number 13 along with item number 13.
No, lordship, that will be a problem for me. That will be a problem for me.
Because lordship, item number 13. I'll be coming.
You're not there in item 13.
I'm there. So a lordship will be inconvenient if it's postponed till late, because I have some problems, personal problems. So
let me be clear.
She can do that.
If item 13
yes
is to be taken up first.
Yes.
And whatever, let's put it this way, if the decision made here or passed here would have an effect on this,
absolutely,
then it stands to reason that item 13 has to be taken up first.
Yes,
but if they stand on totally independent or standalone grounds.
No, item number 13's order will be impacting this case also.
So let her do 13 now, lordship.
Okay, then you can start with 13.
Start with 13.
And then we continue with this.
Yes. Then I'll have to give my reply too.
So, item number 13.
But even here, see, Mr. Sen, even if the issue of maintainability is to be taken up, it would be better if the appeal is being argued, as a whole.
Yes.
Yes.
You argue the appeal on all your grounds, including the grounds of, the objection on maintainability.
Let it be a composite. So in my reply, I will give a reply to everything, because Mr. Sen also has to argue. So if they finish the arguments, then I give a reply to both. I think it will be more convenient for your lordship also.
Yes, Lordship. Lordship, since
Any paper book to be filed here?
Lordship, I am relying on the paper book filed in the in the main appeal, not in the cross appeal. I am relying on this item number 2's paper book. The separate paper book is not required.
But it should have been. You see, even if you are relying on this paper book, you should have prepared a separate paper book, because the parties' name have changed, and it will not be proper for this court to incorporate another, some materials from another case into this case.
Because the materials, whatever is in their paper book, Lordship, it's the same only. Same only, Lordship.
See, look at the index in your paper book. Claim petition of what?
Claim petition will be same only, Lordship.
Evidence same.
Same.
Cross same. All this.
All the same only, Lordship. Because it is this appeal has come from the trial court, so trial court's record will not be changed, Lordship.
Please.
Yes, Lordship. To start with the case, my reply, Lordship, or the cross appeal, Lordship. Here, Lordship, page number 33, annexure 12 of the paper book, Lordship, is the reference.
33.
Page number 33.
Yes.
Is the reference, Lordship. May I draw Lordship's attention to number 6, award amount under section 5 and 7, Lordship. Here it is blank.
Yes.
Nothing is reflected, Lordship. It should have been at least.
You see?
It's clause number 6. Clause number 6 in page number 33. Clause number 6.
Yes.
Amount award under section 5 and 17.
Yes.
It is totally blank. Nothing has been reflected by the DC. The reference itself is defective, Lordship. The compensation paid under section 11 is this, such and such, for land this much, for tree need, for house this much. So now, Lordship, if the award, when the award is passed, in the award it is the solatium is included, but in the reference there is no spell out of solatium. In the award there is, but in the reference there is no spell out of solatium. In the prior to the page is 30. Page number 30 of the paper book, Lordship, is their applications challenging under protest.
challenging under protest.
This is
Their petition to challenge under protest.
section 18.
Section 18. Here also, Lordship, they have not challenged the award.
Yes.
In the para 1, they have specifically stated under protest, it is stated that an award of this much was constituted a portion of rupees this much for land have been made by your honor for the acquisition of land building in the instant case which was received under protest this on such and such date, that the petitioners are the persons interested in the land building manufacturing whose land and portion of constructed building have been acquired and deemed to be demolished, that the land under acquisition process has been undervalued as it is a developed, not the barren hill, and the present market value of the developed land is twice what has been assessed in our case, that the petitioner came to know that the constructed portion has been considered as a single-storied building while estimating the cost, whereas the constructed portion is multi-storied building accommodating the industrial unit of York Print Private Limited, SB Industries and Ballet Herbals. Copy of the map showing the elevations and the area of the building.
Hey, what do you want to say?
Now here in entire petition, they have not anywhere challenged the award. Now, if we come to section 18, Lordship, 18 of the Act, where the reference to the court is made. The Act is may I, Lordship? Section 18.
Yes.
Any person interested who has not accepted the award may, by the written applications to the collector, require that the matter be referred by the collector for the determination of the court, whether his objections be to the measurement of the land, the amount of compensation, the person to whom it is payable, or the apportionment of the compensation among the person interested. Application shall state the grounds on which objections to the award is taken. Here, in this application, no grounds is stated. Provided that every such application shall be made. This proviso is a very important, Lordship. If the person making it was present or represented before the collector at the time when he made his award within 6 weeks from the date of collector's award. Now it is within 6 weeks they need to give this application. They have failed in that. In other cases, within 6 weeks from the receipt of the notice from the collector under section 12 subsection 2, or within 6 weeks from the date of the collector's award, whichever period shall expire first. Now in these applications what they have made is made on 8th of December 2006, Lordship, and the notification which it is said that from the notice from the collector. So it is the notification. Notice from the collector, we called it as notification. So notification dated is 28/3/2006. It's in the reference, page number 33.
(13, 15 or 13?
Page number 33. Page number 33.
What
it
is
is
the date of the award?
Date of the notification. Date of the notification is 6/4/2006.
Where is it written?
It is in clause number 2. Nature of the project, then notification number. Page number 33. In the reference it is there.
What does this notification refers to?
Notification is the published notice to the...
Yes, that is the notification under section 4.
Notification under section under section it is the first notification has to it is a receipt of the notice from the collector. So in this notification,
where is the copy of this?
The copy of the notification is
Section 2 notification. Section 4 notification.
Actually, the date of the award should be 15/1/2007.
The date of the award is
There, you see, below it's written dated Nongpo 15/1/2007.
15 January 2007.
So this is the date of the award.
This is not the award. This is the reference made to the. This is not the award. This is reference made. Reference is not the award.
Okay. This is the reference.
Award is by way of additional affidavit. Award is there.
When is the date?
Well, to just take
But
the
have you-
additional affidavit. In fact, this was never brought on record. Your Lordships had directed us to file an additional affidavit to bring it on record.
What is the
I
date of
filed an
the-
affidavit on 30th of June 2025. The date of the award is 19/10/2006. 19/10/2006. That is the date of the award. What my friend is referring to is the Section 19 statement made by the collector.
Statement made by the
Referring
collector.
the matter of
The
discussion.
reference under section 19. Reference. I am referring to the
You
reference.
see, what you are trying to say is this: your objection, if I understand correctly, is as regard the period when the application was, the reference was filed before the reference court, vis-a-vis the date of the award, which should be 6 weeks.
6 weeks. It should be
So if we
because
take-
reference. My point is that reference is defective, Lordship. The reference made to the court is already is time barred and is defective, and is not maintainable, Lordship.
From 2025.
And also, Lordship, under the LA Act, if reference is time barred, there is numerous judgment where it is stated that there is no condonation. The collector does not have the power to condone the delay of filing of applications before the collector, and also if reference is defective, there is no power to condone the delay of reference also.
Where is the delay?
Come again, Mr. Sen. You said the award was dated
19/10/2006.
19/10/2006.
And we filed in December 2006.
Okay. So reference under section 18 was application for reference was made on 8 December 2006.
Yes.
8 December.
Is that beyond the six weeks or 6 months?
It should be 6 weeks.
18/2.
Within
6 weeks.
Within 6 weeks from the date of collector's award, or from the, and shall expire first. It is also there, shall expire first within 6 months from the date of collector's award, whichever period shall expire first. In other cases, within 6 weeks from the receipt of the notice.
But you have not raised this objection before the reference court.
No.
Lordship, actually, in the reference court, yes, admittedly, we have not raised that one. But Lordship, here the receipt of the notice, whatever is from the 6 weeks from the receipt of the notice, Lordship, as per the Act we go.
Exactly. Since you have not raised the objection before the reference court, then you have to convince this court that this issue can be raised before the first appellate court. And you can come up with authorities to that effect if you feel so.
Lordship, I'll produce.
Please continue.
I'll produce that. Furthermore, Lordship, while making the reference, Lordship, the collector has also failed to take into consideration that in the amount they have made it as a calculations. I mean to say that I'm lacking words, Lordship. Now, the collector, while making the reference, they have not done the calculation is. I mean to say the
calculation of the award that was finally made was made on a wrong basis.
Yes, wrong basis, and solatium was calculated randomly. More so, Lordship, when the claimant, when they were raising the objections, they raised objections on the calculations, not on the award also, Lordship, more particularly. So
award is the outcome of calculation. What else?
No, award is not the outcome of calculation. Award contains when
exactly it will contain all the necessary requirements.
Award contains all the necessary things, but award is not the calculation. More so, Lordship, here in this case, sections 23 is also not complied. Section 23 of the Land Acquisition Act. May I, Lordship?
Yes.
Matters to be considered in determining compensation, Lordship. In determining the amount of compensations to be awarded for land acquired under this Act, the court shall take into consideration: number 1, the market value of the land at the date of publication of the notifications under Section 4, subsection 1. Secondly, the damage sustained by the person interested by reason of the taking of any standing crops or trees which may be on the land at the time of the collector's taking possession thereof. Thirdly, the damage, if any, sustained by the person interested at the time of the collector's taking possession of the land by reason of serving such land from his other land. Fourthly, the damage, if any, sustained by the persons interested at the time of the collector's taking possession of the land by reason of the accusation injuriously affecting his other property, movable or immovable, in any other manner, or his earnings. Fifthly, if in consequence of the acquisition of the land by the collector, the person interested is compelled to change his residence or place of business, the reasonable expense, if any, incidental to such change. And sixthly, the damage, if any, bona fide, resulting from diminutions of the profit of the land between the time of the publication of the declaration under section 6 and the time of the collectors taking possession of the land. 1A, in addition to the market value of the land as above, provided the court shall in every case award an amount calculating at the rate of 12% per annum on such market value of the period commencing on and from the date of the publication of the notification under section 4, subsection 1, in respect of such land to the date of the award of the collector or the date of taking possession of the land, whichever is earlier. Now, Lordship, the award, when the award was made before award was made, in the entire the additional affidavit speaks about the award. So when the award was made, not even a single ingredients of section 23 is reflected in the award. Just the calculation of the land, solatium. Under what, Lordship? If someone is protesting, for example, I am protesting for land, I am protesting for building, I am not getting any relevant amount, market value of the land, I did not get market value of the land, I did not get market value for my building or my crop standing. It should be reflected in the award or in the references which has been made. It's totally vague. Nothing is there. Just stating that the award is it is under solatium is made on 12%, 100% solatium is given, or the calculation of the land per square feet is this much, and based on that some calculation is made. If anything under protest is there, under what protest has to be explained, and also when the award is made before the court, when reference is made before the court, this section 23 ingredients has to be followed. Nothing is there on record. So if the reference is defective, if the award is defective, can it sustain Lordship? Entire judgment by the trial court is defective. Then it has to be quashed and set aside. Furthermore, Lordship, in explanation, it is also given in section 23. In explanation is there. In computing the period referred to in this subsection, any period or period during which the proceedings for the acquisition of the land were held up on account of any stay or injunctions by the court, by the order of any court, shall be excluded. In addition to the market value of the land, and as above provided, the court shall in every case award sum of rupees 30% on such market value in consideration of the compulsory nature of the accusations. These are the provisions given to the claimant or the person who has lost the land. But the main defect is that if the award is not in a proper way, if the award is not passed in a proper way, if the reference is not passed in a proper way, the entire proceedings in the trial court has to be set aside. Lordship, one more aspect of this case is that section 20, service of notice. Section 20, Lordship.
Yes.
The court shall thereupon cause a notice specifying the day on which on which the court will proceed to determine the objections and directing their appearance before the court to be served to the following persons: the applicant and the person interested in the objections, except such, if any of them, as have been consented without protest to receive the compensation award. If the objection is in regard to the area of the land or the amount of the compensation, the collector. Here it is also stated, in this section it is also stated that the area of the objections also should contain the area of the land or the amount, or it is not including, or the amount of the compensations to the collector. So where is in the entire application of there, it is nowhere stated that they are disputing the either the area of the land or compensations. There is no such disputes with regard to when the notice was issued, even on the court's notice also. Now section 22, when the proceedings opens before the proceedings to be open in the court.
Proceedings to be in open court.
Every such proceeding shall be placed in the open court, and shall all persons entitled to practice in shall be entitled to appear, plead, and as such the proceedings in such proceedings. So it is when the proceedings happens, but prior to that, when the section 23 has to be given to the collector has to comply with section 23 when sending the reference. Lordship, I am here relying on two judgments.
You don't have the general citation?
Yes, I need citation.
This one I got from like directly from the Supreme Court's website only.
No, but there is citation.
No, sir. Corresponding SEC citation was not there.
I'll provide the
By
citation.
now it must have been, it must have been there.
I'll provide the citation, Lordship, then.
At least the name of the parties.
Have you given a list of these authorities to the other side?
No, I have not.
You give it. Give it.
The neutral citation is there, 2024 INSC 951.
INSC?
Neutral citation, INSC.
This is a Supreme Court,
Supreme Court
citation.
951.
What is the name?
Name is Banwari and others versus Haryana State Industrial and Infrastructure Development Corporation. Here I'm relying on para 7. May I, Lordship? Para 7.
Please.
This court, speaking through a bench of 3 learned judges in case of Ram Singh Bhai versus Jairam Bhai, has observed thus: it is clear from the opening words of the provision that the oh, sorry, Lordship, I placed wrong judgment. This is redetermination, Lordship. Sorry, Lordship. ये वाला कल हम निकाल के रखें इसका कॉपी कल हम इसका कॉपी I'm sorry, Lordship. I think the copy I.
This is not the judgment.
This is not the judgment.
No, Lordship. Here, this one is. This judgment is about the redetermination, Lordship. This judgment is for the redetermination, Lordship. I made a mistake, Lordship.
Miss, if you're not prepared today, then I think we'll have to take some other day.
Lordship, for the citations, I'll continue with the next date, Lordship, because the citations I already took out citations, but I think some for the citations side.
Sorry, it's yours. I'm so sorry.
So we'll continue then.
We will continue, Lordship.
When? This is just a date. Yes, Miss. Yes.
Whenever, Lordship.
After a week?
After a week, Lordship.
What date? That's If you want to suggest a date, you can do so. Otherwise, we'll fix the matter after a week.
After a week?
Yes.
12th is good, Lordship. 12th. Or is it too early?
Fine.
Lordship.
I think by now, by that time, you can.
Yes, Lordship.
If she gives the judgments and whatever Mr. Sen has to say.
You have not said anything about.
He has not said anything.
As far as maintainability is concerned, you have not said anything.
No decisions have been given as yet.
Lordship, the judgments, I'll place the judgments on the maintainability also, Lordship. I was supposed to place the judgments on the maintainability, but I think I have taken out, Lordship, but I think it is one copy has come out.
But Miss
On the 12th at least.
Chargil, Learned Counsel for the cross appellant. Hearing is not concluded and will continue on the next date fix. As prayed for by the parties, this is matter for further hearing on 12th. So 12th.
Did not come back. Obliged.
Item number, that the previous item.
Item 2 also.
Order.
Together.
That's item 2.
Item number 4.
Yes. Mr. Paul?
My lord, petitioner is missing. This is that Waqf board matter, my lord.
Okay.
The challenge raised by the petitioner is against the constitution of the Waqf.
The constitution or the election?
The constitution. The government, the state has constituted a Waqf board, wide notification. They are challenging that notification, my lord. It's been pending for quite a while. I'm the member who has been selected by the government. I'm not being able to function due to the pendency of this matter.
Any interim order pass?
My lord.
Any interim order pass?
No, nothing. But government refuses to interact with me or deal with me because my constitution is under cloud, my lord. My friend is here.
Is there any time frame for fresh
years.
election, fresh selection, whatever?
3 years, my lord. 3 years. I'm in the third. I'm in the third year.
So eventually, this matter would come in fructus.
I think that is the strategy.
What would be the likely period for the expiry of the term?
I'll just have to check on that, but I believe I'm in my final year.
Month?
I'll just confirm on that, my lord.
Yeah, Mr. Paul, what is the expiry of the term of the committee?
After this order, well, as far as I think, well, we just have to obtain instructions, well, whether this is still contained or not.
It is still continuing. Unfortunately, the notification itself does not contain a time period.
What are there any relevant rules, resolution, or?
It's the WAF Act.
What does the
Act is there?
The Act is there.
What is the prescription in the Act?
Under
You
the
say
Act, I don't think there
you
is
say 3 years, isn't it?
That is my understanding, my lord. I'll just confirm from the statute itself. Section 12 would be relevant. Just a moment.
12 is the thing.
No.
14 is the composition of the board,
Is it board?
Term of office is 15. 5 years, Millets.
5 years. I stand correct. 5 years.
5 years. So 23 millets, 5 years, 28. They'll continue.
5 years.
5 years.
5 years.
Parties.
There is still time, but
parties can still go to the Supreme Court. So, Mr. Paul.
Millets.
Take up the matter too.
Millets, may I pray for tomorrow, Millets? I have not read the file. Your Lordships kindly accommodate us just for the day.
Not tomorrow.
Any day this week, Millets, subject to your Lordship's kind convenience.
Next week.
It has to be next week.
Next week.
But if my friend assures that.
No, Millets. It's a short matter. I don't think it should not take too long.
On Premier Mr. Paul Senior Counsel, seeking accommodation.
9th.
That is adjourned. This is after 1 week.
Next week, Millets.
Item number 6.
You want a fixed date?
9th, Millets, if it is not inconvenient.
That's fine. That's Monday, my lord.
Monday, what is Monday?
9th or 13th, Millets, whatever is convenient.
If it can be 9th, if 13 can be avoided, my lord.
Why?
I may not be here. That's the reason. Any other date?
9th or 10th, Millets.
WAF constituents.
Millets, we'd also just have to examine. I don't know whether it will be relevant for our purposes after the directions passed by the Honorable Supreme Court on this WAF matter, whether it will have any bearing on this. I'll also examine it and I'll place it.
That's on the amendments. My understanding is that it has no bearing.
9th or 10th, Millets, subject to your Lordship's convenience.
We'll have it on 10th.
10th.
Sutra Kalla kini gitu.
10th.
Oh, likely. Okay, fine. 10th.
10th. Obliged. Highly obliged.
Kalau this is better.
Item number 6.
Yes, Mr. Jha.
My lord, my lord, here the petitioner is challenging the punishment awarded to him. Translated copy.
Okay, so you have filed your
My lord, I have filed.
response.
I have filed.
You have received copy.
Yes, Your Lordship.
Let's start.
My lord, I think one document she has to give us to us. She has not. Order is there, my lord. The judgment which was, it is for the convenience of the court. Translated copy. Court has directed to translate the copy and give it to the court. Otherwise, I'm ready.
What is that? Any order pass?
Specific order is not there, my lord.
Lordship,
Not
there's no
before,
such order that was
not
passed,
before
Your
this honorable
Lordship.
court. It was in.
What is
That was the what was the offence, my lord.
translated?
My lord, for me it's
Copy or translated copy?
a translated copy of the offence report. My lord.
Is it
It is in
Hindi?
In Hindi, my lord. For me it's okay, my lord. For the
Where is it?
my lord, it is
Any in the annexes?
it is in the annexes, my lord. Though they have given.
Next year. Okay. This is this annexure 1. Page 39.
No, my lord. That is the I have. It is already there. Translated copy, my lord, of the writ petition.
Yes. Here translated copy is here. Then annexure 2 is also in Hindi, and translated copy is here.
Is there, my lord.
Then
My lord, the respondent has produced the offence report during the time of.
have they filed it with their counter?
No, my lord. They have not. They have produced. This was the offence.
No, when have they produced it? There's nothing.
It is not before this honorable court. Well,
So then in that case, you see, if they want to rely on that,
my lord.
If subsequently in course of hearing,
My lord.
they want to rely on that, then they have to produce a translated copy along with it.
My lord, for me it's okay.
No. First hearing has to resume from the beginning.
My lord.
So in course of hearing, when the turn comes, and they want to rely on that, then they have to file along with it or place along with it a translated copy.
My lord, it's.
But if you see in course of your argument,
My lord.
if you want to refer to it,
My lord.
but it has to be part of the record. If it is not there, then you cannot. If you feel that it's a relevant document,
It's relevant because
then it has to
they are
be-
relying on
then it has
that.
to be brought on record, either by way of affidavit, or you should have done it earlier, or whoever wants to produce it, that party has to do the needful.
My lord, I will translate, and for me though it's for the convenience of this honorable court, my lord.
Naturally, it has to be.
So my lord, I will pray that I will be producing that translated myself, my lord, not by the respondents.
On Premier Mr. Child and Counsel for the petitioner, this is matter of 2 weeks.
Item number 7.
Mr. Paul.
My apologies.
Item number 7. Miss Saraswati Vishwakarma. I think Julia is doing it. No, I know. You don't have to listen to it. Oh, he's there.
Please, Your Lordship. Yes, Lordship, on this matter, I'm appearing on behalf of Estapa, Your Lordship. Mr. Estapa, Your Lordship. Yes, so? Lordship, kindly let the matter come after a week, Your Lordship. He's currently out of station, Your Lordship. On payment by petitioner, this is matter up to 2 weeks. 2 weeks, yes.
Item number 14.
This is an MAC appeal, my lord, which lordship has already heard. It was fixed for submission of written arguments from my side. Written arguments, my lord, are ready. With lordship's permission, I'll hand it over, my lord.
What about the other side?
Other side, my lord, up to them.
Yes, I'm praying for 1 week to file our synopsis.
Mr. General Learned Counsel for the appellant has filed the written argument on behalf of the appellant. Mr. Learned Counsel for the respondent has sought for time to file the response to file his written argument. What he has paid for, this is matter of 2 weeks.
Item number 15.
Please, Your Lordship. Lordship, before my senior starts, my lord, the matter is Mr. Ndishula is leading the matter, my lord. He's before quarter number 2. So, if the matter can come
anyway,
into the court, my
Mr.
lord.
Paul, I think nothing survives in your petition.
Well, it's what we had pointed out to your lordships,
Yes,
and
I
it had
understand.
fallen for my lords also. Your lordships.
Have you by the way, have you filed?
My lords, we filed a bail application that was rejected. Subsequently, my lords, another bail application was filed. That, my lords, only the IO report has been called for, and I'm still in custody. We filed another writ petition, my lords, because my entire arrest itself is illegal.
So, like I said, nothing survives here.
My lords, my humble submission would be, my lords, it again survives. Why, my lords, and I'll again try to, my lords, get back to what I had submitted before my lords on the last date at page 86, my lords. It's a question of law that my lords would have to decide.
But what, see, it may be, but what bearing would it have on
My lords, it would have a bearing insofar as the law is concerned, my lords. Page 86, my lords, I just last second penultimate paragraph, my lords, if my lords kindly see. The bail granted to accused so-and-so by order dated so-and-so is hereby cancelled. The accused is to be arrested and taken into custody in accordance with law. Now the question, my lords, which I had asked myself, my lords, on the last occasion, and which my lords found a little favour with, was, my lords, that once this order is there by a court, my lords, that a person is to be arrested, my lords, what is the procedure to be followed? Whether, my lords, what had fallen for my lords, rather, my lords, just to recapitulate. Well, it's not a case of first arrest, it's a case of arrest after cancellation of bail by a competent court. Whether that would have to be done on the basis of a warrant issued by a court, my lords, or whether, my lords, the police would have the power to again take cognizance of the matter and arrest the accused directly. That is a matter which would then call for some, well, it's decision from your lords.
But you see, that again, Mr. Paul, if you think about it, an order has been passed, a judicial order has been passed.
My lords.
So that
Well,
would
is
take,
the process as your lordship?
It may be right, wrong, whatever,
My
that
lords.
take precedence.
True, my lords.
So on the-
my entire argument is, my lords, this would take precedence.
So on the basis of this order, certain action has been taken.
My lords, which is what I'm saying. If it has to be
Right,
taken,
wrong.
my lords, no, if it has to be taken, it has to be taken in accordance with law.
So what you have to do is,
My lords.
you have to assail this particular order.
This is what is under challenge before my lords. This is what is under challenge.
As far as
This matter is
the
concerned.
implication of this order is concerned.
Lordships. This is under challenge before my lords. Which is why I say, my lords, the issue of law survives. The bail part of it, my lords, as rightly fallen for my lords, I have to explore alternative remedy. I'm doing that. But this is the issue, my lords, which would survive. That, my lords, once a bail is cancelled by a court, my lords, the arrest, the re-arrest would be, my lords, if it is on the direction of a court, would have to be under the, my lords, powers vested on a court. And that, as your lordships are aware, my lords, the process for compelling appearance, my lords, is very specific.
Even otherwise,
My lords.
see, we can assume that the power is made, you see, the inherent power of the court has been exercised.
No, that's okay, my lords. Till exercise of this power, my lords, okay. Now the question is, my lords, that if I am to be arrested, how am I to be arrested? My lords, as your lordships are aware, my lords, the court may say that this person is to be arrested. If he is to be arrested, my lords, it has to be under a valid warrant issued by the court.
You will be hounded and arrested, that's all.
We were, my lords, we were arrested in Guwahati airport in some third state, my lords, without a warrant. And, my lords, very interestingly, I am shown arrested in Khanapara PS. On that issue, my lords, we've moved a writ petition today and notices have been issued. Just to, my lords, for procurement of the CCTV footage as to where I was arrested. Let this matter come up, my lords, in a day or two. If Mr. Shulai is not there, we'll because this is a very important issue of law, my lords. Otherwise, also I'll submit that some clarity should be there from this honorable court as to how an order of a court, my lords, the process would have to issue. Admittedly, there is no process. The arrest memo simply says, my lords, that I was arrested in Khanapara PS. No warrant admittedly issued. The remand order, my lords, passed simply says that my lords have heard the matter is pending before this court, but there is no stay, hence police can arrest.
Fine. We'll have it up to 2 weeks then.
My lords, may I pray for next week sometime?
Next week we may be a bit because you have to understand this court, you have to sit DB here and there and whatever. By the time it may be listed, no doubt. It may come out, it may not.
The difficulty is, my lords, what has happened is because of all this, my lords, this person's been arrested, my lords, last 6 days or 7 days he's been in custody. While we are fighting out the legal battles, my lords, this poor man is in custody. That's the only reason, my lords, are spring. Maybe next week, my lords, subject to your lordship's convenience.
On preliminary parties, list is matter after 1 week.
Obliged.
Item number 18.
Please, Lordship. Lordship, in this matter, we have this council has passed the order, subsequent order.
Right, Your Lordship, during the pendency of the repetition, they have issued us a show cause notice to reply again to what has something already been settled by the inquiry officer. I don't really understand on what basis it's been done. But once there is a exoneration order by the inquiry officer, that is why we have come before this court for a reinstatement.
Oh, that is your prayer.
Now again they have issued us another show cause notice on those charges which has already been settled by the inquiry officer. They've asked us to show cause within 15 days.
But that would be a separate proceedings altogether.
Lordship, you can see from para 7 of this.
You see, what happened is the petitioner has come before this court with a prayer of seeking direction for his reinstatement.
Absolutely.
Which was not done so by you.
Yes.
Now, in the meantime, you have come up with this, asking to show cause and whatever. Is there any specific order that in the meantime he is not to be reinstated?
No. It's very vague. That's why my submission is.
Because if that is so, then it would have a link, as far as this petition is concerned. You would have, filed your counter in that regard. But then, if it is not so, then why would this matter be brought up before this court today? As far as the show cause is concerned.
Lordship, actually direction has been issued to the petitioner regarding, because the council has examined the record and has found that petitioner has admittedly received some amount.
Oh, that is it.
And that is, Lordship, so
Those
direction has
matter
been
of facts.
issued.
Your Lordship,
So
what
it
was
appears,
inquiry was instituted on the basis that there was a misappropriation of money. So there were several charges against me. There are 12 charges. Now, since the issue was with regard to misappropriation, there was an inquiry conducted. We participated in the inquiry, and even the complainants, because this inquiry is on the basis of a complaint filed by a private party. So now the District Council, taking seize of the matter, has appointed a judicial officer to inquire into those allegations made by the complainant. Now those charges have been, statement was recorded, there was evidence taken up before the inquiry officer. Now the inquiry officer has come to finding that there's no misappropriation, but there's only procedural lapses. Now the District Council, after that, then there was no reinstatement order. Prior to that, they issued us another show cause notice to give your comments on the inquiry report. We replied to the inquiry report. Even the complainant also replied to the inquiry report. My humble submission, what I've learned is that even the complainant also have accepted the inquiry. Now, there was no reinstatement order even after representations been made. So I've come before this court, before the closing, before the vacations. Now they were supposed to take instruction. They said it's the matters under consideration. Now, surprisingly, we've been issued with another show cause saying that no, they're not satisfied with the findings of the inquiry officer. Now they've asked us to show cause again. In my humble submission, there is only a case you're trying to victimize me. Then what is the object of that inquiry? I mean, the entire object of that inquiry has lost its significance.
Lordship, actually,
is there any process as far as the inquiry report is concerned? If the same has not been accepted by the EC,
there was a case, Lordship, in 2000. This is regard to inquiry against the SAM of Noston in the year 2000. There was a finding that he was exonerated from all the charges. There was no reinstatement order. But the District Council, what it did was they issued a subsequent notice similar to our case. Then, after a show cause notice was a reply to the show cause notice, they were not satisfied. They institute another inquiry of 2 members. Then the person concerned, aggrieved person, came before this court. Then this court decided that the question of a second inquiry does not arise. So he was directed for reinstatement. Because it's very vague. If they say, okay, what they're asking us is you pay your share.
Whatever the case may be.
Lordship.
Whatever the case may be. You see, if you have to file your response to this show cause, you do so. That is up to you. In the meantime, as far as this matter is concerned, the respondent should file their counter and see. Once the pleadings are in place, then the matter can be finally heard. And if this is to be, put up by you by way of an affidavit or, as part of the counter, then so be it.
Yes.
But have you have filed your counter?
No, my lord.
But why was this matter put up for hearing?
It's in the list, in the hearing list.
Hearing list.
It should have been in the order.
It should be in the order column.
This court will not take this into consideration
Yes,
as of
this
now.
still-
We'll take it back. But I'll direct you to file your counter.
Yes.
You can do so.
And your lordship will take steps on the complainants.
Okay. Oh, they have also.
They are because they are part of the proceedings.
No, have you taken steps?
Not yet, because it was moved before the ensuing vacation, so they're only supposed to take instructions first.
Respondent number 5. But there's an order here as far as respondent 5 is concerned. Yes.
5, lordship.
You've been allowed to take steps, and also by dusty service.
There's a lapses on my part. Apologies.
Mr. P. Nombril and the counsel for the petitioner has submitted that through inadvertence, steps for issuance of notice on the respondent 5 has not yet been taken. It is prayed that pursuant to this court's order dated 17/12/2025, steps be allowed to be taken for issuance of notice upon the said respondent number 5. Pray aloud. Mr. R. Rashad Leonard, counsel for the respondent 124/KCTC, has submitted that we be allowed to file the affidavit in opposition on behalf of such respondents. As prayed for, this is matter after 2 weeks.